Good morning. On behalf of Public Services International, focus on global change, focus on the global south, IT for Change and Third World Network. We welcome you to this webinar on digital trade rules and industrial relations. This is the first in a series of 3 webinars that we are organizing, looking at different aspects of digitalizations, of digital trade rules and workers' rights. What we have as an intent with this session is that it will be quite interactive. So we will have 3 short interventions and we will open for a few questions after each of them, as well as keep some time at the end of the meeting for a more overall discussion. And the idea is that this is really a space where it's a small group meeting. Most of you already know each other. Most of us know each other. And the idea is that it's a space where we are comfortable to deepen our learning, consolidate our learning, bring questions and also maybe doubts that we have. So we really hope that you will feel very free to intervene. You can put your questions at any point in the chat box. And then, as I was saying, we will open for a few questions after each intervention and keep some time at the end also. So we are talking today about digitalization. And really this is not limited to the gig economy or the platform economy. And we can see that it is advancing with different paces in most sectors. We are seeing the entry of technologies that collect data of consumers, of workers, on the work that takes place. And while we can see that gig workers or platform workers are facing challenges that are specific to them, some of the challenges they face are also, general challenges that informal workers face. But we really want to try to understand what is specific, how is that element of digitization exacerbating or modifying some of the challenges, how it is mediating employee-employee relationship, how it is playing a role, data and algorithms are playing a role in defining people's wages, their work allocation, impacting on intensification, and really remember that when data is collected individually, it has a certain value, but it's really when it gets aggregated in a workplace or in a municipality or at the national level that it gives a certain intelligence to companies, and that they are really using this to advance their control and their power, of course, on the economy, on the market, on consumers, but also on workplaces, on labor markets, on workers and therefore on unions. So as we are trying to understand the specificities that are brought by digitalization, that will make us better equipped to anticipate what is coming out in our workplaces, recognize it sometimes when it's just emerging, and also to discuss together, identify ways to intervene beyond the workplaces, through policies, articulate positions and demands that look at what are the kind of regulations that are required, and also what are the kind of harmful regulations that are being proposed, standards and regulations that are being proposed, including sometimes through international trade agreements. So with this intent, we have today 3 speakers that I really want to welcome. We have Brother Sangam Tripathy, who is the Assistant Regional Secretary for International Transport Federation. And he is going to talk to us about how tech companies are using the data that they collect to their advantage in industrial relations. We will then have Madam Ramapriya Gopalakrishnan, who is a senior advocate, very specialized on labor issues, labor lawyer. She's going to talk to us about the gaps in existing labor laws, in the view of these advances of digitalization, and I, I guess also in the context of the codes that have just been passed. And Professor Shamsunder from the Xavier School of Management in Jamshedpur, who is going to then look at the implications of digital trade rules for industrial relations in India. So with this, I again welcome all of you and welcome them on behalf of the organizers, and I invite Brother Sangam to start with his intervention. Thank you.
Good morning and namaskar. How much time do I have, Susana?
10-12 minutes?
How much?
10-12 minutes?
Yeah, sure. Thanks. Okay. So good morning and namaskar, everybody. I'm going to focus my intervention today primarily to the app-based transport workers. We are talking here about the Ola Uber drivers that we see all around in our all over our country in all the cities and metros. So this is part of the gig economy, the app-based transport category of drivers. They are platform workers controlled by platforms like companies like Ola and Uber. And for the past 2 or 3 years, we have been trying to work with these drivers, trying to organize them, because like Susana said, this is a new category of workforce which is going to dominate over the coming years, you know. So the gig and the platform workers are going to rise, and their numbers are going to rise in millions and millions. So we will have, this is the new workforce that we will see in the future years. So it's time for the unions to kind of start concentrating on these workers and trying to organize them with their very typical problems. So just because I think there is a lot of there are a lot of people from the grassroots levels and the PSI affiliated unions. I would just like to spend 2 or 3 minutes just trying to brief them or brief everybody about this new category of workers that we've been now seeing for the last 10 years or so. So just to give you an idea, if we talk about India, today we have something like 30 to 35 lakhs of Ola Uber drivers all over the country. So this gives you an idea of the huge numbers. Now, today, if we look at these drivers, they are kind of entrapped, you know, in the vulnerable and the marginalized. So they are like the unorganized sector workers. And why do we say that? We say that because probably 5 years ago, 10 years ago, when they came into this employment, there were big dreams offered to them that why should they work for minimum wages of 7,000, 8,000? They could become a driver. They could log on to the Ola Uber app and then work as much they like, then go home and rest, and then come back again. So there is no employer to tell you that you have to come and work for 8 hours or so on and so forth. And there would be big earnings when they would be driving. And initially for 1.5 years, all of this dream looked like a real dream. So people driving Ola Ubers, taxis started earning 30,000, 40,000, 50,000, 60,000, 70,000 rupees a month. And everybody thought that, now this is going to be their employment for their whole life. And of course, when you start earning well, many of the drivers thought that why should I just ride one taxi? Maybe I will go to the bank and, take loan and buy another taxi. And I will drive one and I will hire a driver to drive the other one. And so drivers went forward and, bought more cars and for their taxis, because you did not need a permit. You did not need RTO authority clearances or anything. You just go to the bank. Ola or Uber will give you a letter, go to the bank, buy a car, start driving from the next day. No questions asked. Anyway, within 1.5, 2 years, this whole dream started gradually crumbling, and the incomes started coming down. Now, when this started happening, the 70,000 rupees per month earnings started coming down to 50,000 rupees, 40,000 rupees, 30,000 rupees. And today, to cut the long story short, today a driver drives a vehicle like Ola and Uber for 12 hours to 14 hours and hardly carries home 10,000 rupees, 11,000 rupees a month. This is after deducting all the petrol costs, the maintenance costs, the commission costs paid to the companies, so on and so forth. So earnings have come down terribly. Secondly, they are now entrapped in debt. So they have to pay their EMIs. They have taken loans. Those loans have to be paid off. And so what is happening today is, and of course everybody knows about how the pandemic or the COVID-19 situation since March, when these people, because these drivers, you know, when they drive, they earn. When they don't drive, they don't earn. Simple. So it's like a no pay, no work situation. And so since March, of course, they have been in a very bad in a very bad economic condition, social condition. And so all these liabilities today have made these workers in, a big group of workers who are suffering a lot. So how did this happen? There is technology behind this. Okay. So coming back to the point, all of this has not happened because, of some other issues, but just because the control of technology is with the companies. And over the years, that control has enabled this kind of a situation. Now, to go into a little more detail, this system of technology, it is opaque. When we say opaque, means it is not transparent. It can be manipulated. It can be rigged, although the companies say, oh, we are just using algorithms. These are algorithms which are based on artificial intelligence, so on and so forth. And there is no human control, but it is all fake. It is all lies. A lot of this system is very, very opaque. So if we talk about issues like fares, now you want to go from point A to point B. What you will be charged, there is no guarantee that another customer traveling that same point A to point B will also be charged the same. So who determines the fare? They say technology determines the fares, but there is ample proof with us to prove that what you are charged for point A to point B may not be charged, the other customer may not be charged. There are issues like surge pricing. Now who controls this surge pricing? Definitely technology controls, and behind the technology are these companies. So when you travel A point to B point at 12 o'clock in the afternoon, you pay a different amount. When you travel point A to point B at 6 p.m. in the evening, now they will say, oh, there is congestion, there is traffic jam, and therefore we need to hike up the prices. But this is all humbug. You can even be charged surge pricing at 11 in the morning when otherwise, everybody has gone to office, so on and so forth. So again, control. The incentives that the drivers are paid, there is no uniform basis on which the incentives to the drivers are paid. The penalties which drivers face, and we have collected ample data to prove these points. The bonuses that drivers get, the fixing of the rides. I'm a driver. How many rides will I get today? How many rides will Mr. B get? How many rides driver C will get? How many rides driver D will get? There is absolute opacity in this whole system. And then, the work practices, working conditions have become so dehumanized. Now, normally as workers in any sector, you have a grievance redressal machinery, you have a grievance redressal point, you have a grievance redressal mechanism. But here in Ola and Uber, you don't have any grievance redressal mechanism. Okay. You work for long hours, you have problems with your bonuses, you have problems with your health and safety, you have problems with your trips. You are logged off suddenly, by the company, and you try to approach the company, you have nobody to answer your questions. So this is dehumanizing. And of course, I could give you stories and stories about the health and safety problems that these workers face because of 12 hours and 14 hours of driving. We have made intensive surveys and researches to find out how the incidence of kidney diseases, how the problems of piles, for example, is rampant amongst these drivers when they're sitting on these Rexine seats for 12 hours, 14 hours and driving. Now, third point is about the state apathy, So right from the beginning, as these workers started, their problems started coming to the fore, and the unions, other organizations, research organizations, NGOs started understanding their problems, various representations were made to the state to say that, this is a growing sector. We need to regulate this sector. It can't just go on like a monster, without any regulation. But all of us here, I think, know that there has been absolutely no regulation. Now, last week with the passing of the Social Security Bill, this is probably for the first time, that the government or the legal machinery is now talking about some sort of social security. I think Sister Rama Priya and Brother Sham Sundar will tell you more about it, or we can have a discussion later on this. The fourth point is about wage theft. So again, how these big companies control things, or control their workers. Now, we have done lots of studies with drivers. So these drivers, they get a weekly Excel sheet, that Excel sheet tells them from Monday to Saturday, how much did you ride, what was paid to you, what was the commission, what was the GST, what was the incentive, what was the bonus, what was the deduction, what was the penalty. All of that is said in, is recorded in these Excel sheets. And we collected a lot of Excel sheets over the last 2 years from the drivers. And you can see a lot of instances where there are actually wage thefts of these workers. So what they should be earning and what they're actually getting, you can actually see from these Excel sheets how those wage thefts have been made. So it's like shortchanging the drivers for their earnings, So in terms of commissions, for example, Ola Uber says we only charge 20% commission. But these Excel sheets show how in many cases, sometimes these commissions go up to 30%. The tax on fare. Now there's a set procedure on how the tax is to be charged, like the base fare. But then when there is a problem with the base fare, or when there is a problem in the calculation of the fare, the tax element also. So they're even cheating the government on this, there is no uniformity on how deductions are made, How much time do I have, Susana?
You can start wrapping up.
Sorry?
1-2 minutes. Just if you can wrap up.
Yeah. So there are a lot of these instances where we have even come. Now, the last point I want to share with you is about, the data issue for the platform workers. Now, in our country, of course, all these things that I have told you kind of prove how algorithm manipulations take place and how these companies manipulate data. There's a lot of data surveillance, in the case of our drivers also. I could give you more, so many examples. Now, this new law, which is going to come, it was supposed to come now, but I think the committee has again asked for postponement until December. The Personal Data Protection Bill. Now, this law doesn't have any mention about how personal data or the workers' rights, workers' data is to be made public or something, So now, the last point I want to make here is that we are trying at an international level right now. Well, our local fights carry on with the unions. We have organized around 25,000 of these app-based workers. All those fights carry on, But at the international level now, the one thing that we are trying, and this is one of our unions from the UK, and 2 drivers have gone to the district court in Netherlands. And they are raising a complaint against Ola under the GDPR. So, that the European Union has a GDPR where, every worker has a right to personal data. And on 10th of September, that's just 2-3 weeks back, 2 drivers from one of our UK unions have gone to the Netherlands District Court to raise a complaint citing the European GDPR. And I could go into the details of this case, how it has raised issues again based on proof of how drivers have been cheated, and that information has not been shared with them in terms of their deductions and in terms of the penalties which the company is duty bound under the GDPR. So this is one area where we are looking for, I mean, this will probably open up some new avenues, in the future. So I think I will stop here, and then maybe in the discussion, if something comes up, I can always join in. Thank you very much.
Thank you very much, Sangam. I think to me it was very like the numbers you gave in terms of where the workers started, where the drivers started, and where they are now in terms of what the remuneration of an Uber or Ola driver is very telling of how that control through technology over the labor market. I mean, there is a side that is for the consumers, but there is really a side that is on how this is controlling the labor market and the working conditions, the elements of intensification of work conditions that you described. And I think we are coming into this element of digitalization. You spoke of these calculations, these algorithms that are kept opaque by design by companies so that they can actually do wage theft, so that they can design work practices that are allowing them to extract more profits, and how they are ensuring that the calculation behind the algorithms are not made public, are not made available to the workers. And this is actually so strange, right? Wages should be something so transparent for a worker, and here it is not. It is in this black box. So thank you so much. I just want to open it if there are any questions directly now to Brother Sangam. I think what would be interesting for us is to try to see also what do we see coming up in public services workplaces. Of course, it's not exactly the same thing, but there is an element of certain technology that are coming in that are also showing the entry of these technologies can also have an impact on work practices. And this is the kind of things that we also want to understand. If you would like to speak, you can unmute or raise your hand.
Hello.
Yes, Manoj.
Susana. I would like to mention that in recent Social Security Act, these gig and platform workers are also covered somewhat. So will that make any difference to them?
Well, it's
I'll
too
just
early.
check. Okay, please go ahead.
It's too early to say that. We have already, during this very short session of the parliament, prepared various critiques, working alone in ITF and also working with the other groups, NGOs, trying to find out what are the loopholes, what are the gaps in this bill. So on the one hand, I will say yes, for the first time, at least somebody is talking about social security for these workers. But if you read the code as it is now approved, there are a lot of gaps, there are a lot of things that need more clarification. Otherwise, what will happen is, sorry,
You are on mute. Yes.
it will be misrepresented, it will not be presented in the proper way, rules will not be made properly. So it's too early to say that, but yes, there is a lot of work for the unions and the NGOs and the other civil society groups now to work to ensure that the real intentions and the objectives of the bill are achieved.
Thank you.
Thank you.
Yeah, can I come in?
Yes, of course.
Sangam, thanks for the wonderful presentation that you made. There are two issues that I would like you to respond. One is that with the ITF, is it possible to have some kind of a global regulations governing this entire at least app-based labor market system, along with the other players and in consultation with ILO? I am told that ILO is engaged in this task. Umar Ani in ILO is one who is preparing the reports. This could be kind of an overarching institutional framework that could be evolved, designed rather, keeping in mind the peculiarities of the countries, member countries and others. Secondly, I mean, you are in touch with me, but it would be nice if you shared the documents that you had. You have concerning the critic of the inadequacies of the Social Security Code concerning the platform and gig economy to all our constituents who are here, and also that would be great because some of us like Rama is there and I are there. I mean, we do write, as all of you know, and it would help us to sharpen our critique much better. And of course, the ITF and your union needs no introduction for the good work you people are doing. But this is what I just wanted to submit. Thanks, Susana.
Yeah.
Thank you so much, Sangam. I would just request you if you can hold on the response to the global platform, because it links with what we want to have as kind of the last discussion. So if you can keep that response and we can go back to that towards the end. And I think on the occupational safety and health, it's a request for the document itself. So we might not elaborate on that right now. Is that okay? Yeah. Okay, so, and I think it also kind of connects nicely with the next speaker, which is Advocate Ramapriya Krishnan. Advocate, we have just seen the passing of the last 3 labor codes this week, including one that looks at industrial relations. And the previous laws did not really address the question or the reality of digitalized workplaces, of gig economy, platform economy, not enough for sure. Digitalized workplaces also not. Their diluted form might also not be able to do justice to these issues. So can you tell us a bit about some of the gaps in legal terms, and if you could maybe, of course, speak of the platform workers, but if we could also try to look beyond that in terms of digitalization in the workplace. Over to you, Ramapriya. Thank you so much.
Good morning, everybody. Thank you, Susana. Thank you, Brother Raman Kannan, for inviting me to speak here. So, since the mid-90s, as you all know, there has been a sea change in the world of work in India with the mushrooming of IT and ITES companies. There was a sea change in the world of work. And in the last 10 years, there has been a further change in the world of work on account of the rise in the gig economy, with various aggregators like providing food delivery services, like such as Zomato and Swiggy, and those providing transport services such as Ola and Uber and all that. There's been a big change in the world of work in India. So what I'll be speaking about now in brief is whether the labor laws of the country are adequate to protect the right to decent work and decent working conditions of workers in the IT, ITES, BPO sector, and of the digital platform workers or the gig workers. Because as you all know, everyone in the world of work has the right to decent work and has the right to decent working conditions. But do the labor laws afford adequate protection for that when it comes to gig workers and when it comes to workers in the IT and ITES sector? So this is what I'll be speaking about this morning. Now, the majority of the labor laws in India, as you all know, were framed many years ago. Most of them are at least 50 years old. Some of them were framed prior to independence. For example, the Employees Compensation Act, which was earlier called the Workmen's Compensation Act. It is a law of 1923. Then we have the Payment of Wages Act, which is an act of 1936, and so on. So even the latest labor law, if you think, I mean, I'm not talking about the POSH Act now, which is more recent, but otherwise in terms of labor laws, we generally think of the Interstate Migrant Workmen Act as the latest law. And that is also a law of the year 1979. So at any rate, everything is of at least 40 years plus vintage, with the exception of the POSH Act. And so these laws were framed keeping a regular permanent workforce in manufacturing establishments in mind. So they did not visualize any other kind of workforce except a regular permanent workforce and some badli workers who would come to seek work there. So this is what they had in mind when the law was framed. They never envisaged a situation where the workplace would be outside the premises owned by the employer, outside the boundary walls of some property owned by the employer. They never envisaged work from home. They never envisaged flexible working hours. And so these situations were never visualized when the laws were framed, and they never visualized a situation where workers would be designated as managers and executives, and they would work as part of projects, lead teams, and so on. All this was beyond the comprehension of the law. So the laws were also framed keeping in mind a large workforce in a particular one common workplace. That is why most of them also have number thresholds. For example, the ESI Act, it applies to establishments where 10 or more workers are employed. The PF Act applies to establishments where 20 or more workers are employed. Maternity Benefits Act, 10 or more workers. Payment of Gratuity Act, 10 or more workers, and so on. That is why all these number thresholds are also there in the laws, which restrict the application of the laws. Then there are also wage limits, wage thresholds also, which restrict the application of the law. For example, the PF Act, it does not apply to employees who draw wages over a particular limit. The ESI Act does not apply to workers who draw wages over a particular limit. So these income thresholds and numbers threshold restrict the applications of the labor laws. And besides that, of course, there's the definition of the term workman or employee, which decides the applicability of the laws to a given set of persons in the world of work. Now, if you look at the definitions of the term workman or employee, it is again relatable to their work in a particular industry or in a particular establishment, which is again the manner in which it is defined. That would exclude people like gig workers. The definitions are not wide enough to accommodate this. So the as a combination of this income threshold, wage threshold, and restrictive definitions of terms like a workman, worker, an employee, and so on, gig workers stand excluded from the scope of most of these laws. And now the codes were passed in 2020. They were passed now. No, they are not laws which were passed some 40 or 50 years ago. They should have taken into account the situation. The definition of the term worker or employee under these codes should have been wide enough to include gig workers. But unfortunately, except the code on social security, gig workers do not come within the scope of the other three codes. They do not come even within the scope of the code on wages, which has already become a law. Now, because of these restrictive definitions, even IT and ITES workers have had a difficulty all along in claiming the protection of these laws. I have dealt with several cases relating to IT and ITES workers. And now, because they're designated as manager or executive, usually the very first question, even when we file a petition for conciliation, the very first question that usually arises is whether so-and-so employee is a workman under the ID Act. He cannot be an employee, he cannot be a workman because he's a manager, he's leading a team, and so on. So many of the cases are thrown out simply on the ground that the employee is not a workman. Though the Supreme Court has repeatedly held it's the nature of work which is decisive, or whether a person is a worker or not, and not his or her designation. But on the ground that they are not workmen for the purpose of the Act, many are thrown out. And this also makes it easier for employers to effect large-scale terminations, which the terminology generally used in the IT sector is layoffs. They call them massive layoffs. And when these massive layoffs happen, it's not possible for the workers to claim any protection under Chapter 5B of the Industrial Disputes Act because they are not considered as workmen under the Act. So that is the fate of the IT and ITES workers. Now coming to the gig workers, as you all know, they don't have a common workplace. Whether it's food delivery, persons engaged in food delivery or as cab drivers, they don't have one common workplace. And then they do not have a contract of employment. They do not have a typical contract of employment. And so the companies that engage them insist they are independent contractors. They say they are independent contractors, they are not our employees. Now, how do we ensure protection for the workers? There are two obvious options is why either the existing laws, either amendment should be made to the existing laws, the existing codes, the definitions of workman, worker slash employee should be widened to bring them within the scope of these laws. Or the other option is that a sector specific new law should be framed to give proper coverage to these workers, to ensure that they have certain basic rights regardless of their employment status. Because as you all know, regardless of one's employment status, everyone in the world of work should have certain minimum protection. Everybody should be entitled to a minimum wage, whether the minimum wage is going to be paid by the hour, by the day, or by the month. Everyone should have a right to a minimum wage. And to ensure uniformity and no variation from state to state, there should also be something like a national minimum wage, which everyone should be entitled to. Then secondly, no one should be required to work for more than 8 hours a day and 48 hours a week. If they are going to work beyond 8 hours a day or 48 hours a week voluntarily, they should not be forced to do that. If they work voluntarily beyond that, subject to certain limits, then they should also be given overtime at twice the rate of wages. Then everyone should have the right to paid leave, sick leave, maternity leave. Then they should have the right to compensation in the case of any employment injury. An employment injury should not be construed as mere physical illness. Even mental stress, fatigue, provision should be made for that, because mental well-being is as important as physical well-being. Then gig workers should also be entitled to welfare benefits like other workers in the unorganized sector. Then there must be also some kind of protection against arbitrary termination. I know this may sound a bit incongruous when I say that they are not considered as employees, but there should be some kind of protection so that they are not, arbitrarily taken off the, stopped being assigned work. There should be some kind of protection. Then they should have the right to form and join trade unions and exercise collective bargaining rights. This is one of the things that I wanted Brother Sangam to elaborate on a bit. His experience of unionizing the gig workers, and whether they've been able to engage in negotiations for employers with them and achieve any good results. So maybe that is something he can talk about later on in the course of the discussion. And then very importantly, as Brother Sangam had already pointed out, gig workers should also have access to proper and expeditious, effective, impartial grievance redressal mechanisms, because they also have grievances which need to be addressed expeditiously, and there should be proper modes of grievance redressal for them. Now, because the time is very short, I don't want to go into each of these aspects, but just would want to touch upon a law specific to gig workers in the state of California. In USA, there is a law called the AB5 law, which was framed pursuant to the judgment of an employment tribunal in California in a case called the Dynamics Operation West Incorporated case. Now that law, the AB5 law, it lays down three criteria, which are called the ABC criteria, to decide whether or not a worker is an independent contractor or an employee. And the three criteria are, the law says that a worker qualifies as an independent contractor only if he or she satisfies the following triple test. And the triple test, which is also called the ABC test, is what I'm going to read out now. One is he or she should be free from the control and direction of the hiring entity. Then the second test is that he or she performs work outside the usual course of the hiring entity's business. And the third test is he or she is customarily engaged in an enterprise or establishment or trade or occupation of business of the same nature as that involved in the work performed. Only if these three tests are satisfied, a person can be called an independent contractor and not an employee. And if you look at these three tests, one is that they are free from the control and direction of the hiring entity. Ola drivers or Swiggy, delivery boys, they are certainly not free from the control. of the employer. The employer may not be, micromanaging their work by supervising them from minute to minute or giving them directions every minute, but they are told how to behave, what to do, how much they can charge. So that amounts to control. Then secondly, only if they are performing other work which is completely outside the usual course of the hiring entity's business, only then they can be considered to be contractors. If this criteria is applied also, then none of the, I mean, all the Ola and Uber drivers or Swiggy and Zomato delivery boys, they'll all be the employees of those companies. Secondly, if they're engaged, uh, if he or she is customarily engaged in an enterprise or establishment or trade or occupation or business of the same nature as that involved in the work performed. For example, if a driver of an Ola car is also running a travel agency, and is running a travel agency employing 5 other drivers, then he or she may not be an employee for, but can be considered as an independent contractor. But otherwise, to call them a independent contractor is it's a misnomer. It's nothing but a device to disguise the employment or camouflage the employment. Terms like manager, executive, and independent contractor, etc. These are misnomers, and these are devices to camouflage the actual employer-employee relationship between the aggregator and these people who work for them. So the law, so
Thank
on the
you.
lines of this law, even in India, they should make a distinction between independent contractors and employees. They should be considered as employees for the purpose of the labor laws, and either sector-specific laws should be framed or they should be brought within the ambit of the existing laws and codes. Thank you.
Thank you so much, Advocate Ramapriya. I think it was very compelling how you presented the fact that the labor laws that are 40 years old might not have taken this aspect into account, but the new codes have also failed to do so. The kind of specifics that you mentioned and the kind of structure, I think, really helps understand what is the situation for gig workers. And I think there are elements there that people from services sector and public services can also build on. I'm just going to open it for questions. I can see 2 hands. I'll start with Jammu and then Prakash. Yes, please Jammu start and then we'll ask Prakash also to speak.
I just want to know the difference between workers enjoys or derives right under a law and when the worker enjoys right under the code. What is the difference between these two? Because now the laws have been, replaced by codes. So how it is going to impact as far as a right of a worker is concerned, and how it is going to impact on the process of adjudication of any issues before the conciliation authority or in labor courts or the industrial courts, because now it is not a law and these are the courts. The courts have to deal the violation of the law. So therefore, I want to understand how this rights of the workers impacts when it is being derived under laws and when it is derived under courts.
Okay, so this is the first question. We'll just take Prakash's question so that you can respond to both. Prakash, you're muted. You're muted, Prakash. Prakash, you are muted. Yes, now we can hear you.
Good morning. See that while discussing the issue relating to labor law, I think one of the law which existed for 50 years back, Contract Labor Regulation and Abolition Act 1970, it opened the people who are also working outside the premises of the employer. Now, another point which I say that since 1947 till 90s, 1990s, what we found that there was a protectionism to the labor by legislation, that the intention of the government always used to see that the weaker section of the society being a labor protected by that. Maybe the reason is the unorganized sector, more unorganized sector. Then we had contract labor is always has been seen that in a perennial work, no contractor should be appointed, no contract work be there. And another point which I wanted to know from Sister Rama Priya is that how that employer-employee relationship is established. Because even you take the new codes, we do not find that specifically how the employer-employee relationship. What we gathered from Supreme Court judgments are that a contract of service is an employee-employer relationship, whereas the contract for service is a contractor who has no control, no control over the contractor. So I think that just we compare the earlier laws and these codes, we will have to see a serious think about FTE, fixed time employment. So that remains that hire and fire. So every employee will be the fixed employees henceforth. That will be a very serious concern for the labor. Then 300 and more employees employed, then only permission of the appropriate government is required. This will take away, I think, about 95% of the establishments out of the coverage, and that makes a very serious issue for, and that maybe that should be our concern, and for even core group this should be taken seriously, because we should oppose on this, because 300 and above only very few companies are there. So for layoff and retrenchment, I will just wanted to initiate this discussion on these issues, because now new codes have come in, and therefore industrial relations is one of the most important law which we require discussion on that. Thank you.
Thank you so much, Prakash. Is there any other
Respond to
question?
these
Yes.
issues?
Yes.
Firstly, coming to what Mr. Jammu spoke about, he was asking about the difference between the labor laws and the codes and the rights protected under the laws and the codes. Basically, these codes subsume the existing laws. For example, the Industrial Relations Code that subsumes the existing Trade Unions Act, the Standing Orders Act, and the Industrial Disputes Act into itself. So these laws, these codes consolidate the provisions of the laws. At the same time, they have made certain important changes to the laws. Some of the changes were pointed out by Brother Prakash. For example, the rise in threshold from 100 to 300, and the allowing fixed term employment. These are some changes which have been brought about by the IR code. But it's by and large, these codes have subsumed the provisions of the existing laws. So unfortunately, most of the lacunae in the existing laws, or most of the gaps in the existing laws, have also gaps in the codes. For example, the code on wages and the code on occupational safety and health, and the code on industrial relations, they do not take into consideration gig workers, for example. So there is one gap which existed prior to this enactment of these codes, and that has slipped into the codes as well. And these codes are not yet law, because the procedure of assent by the president and notification still remains. So, I mean, we are virtually there, but we are not yet there. So as on date, it's still the Industrial Disputes Act or Trade Unions Act, which applies as on today. And then many other lacunae, such as like the wage thresholds and the numbers threshold, they have also slipped into the codes. For example, again, PF under the PF code is applicable only to employees drawing, to establishments having over a particular number of workers and so on. So many of these shortcomings which were there in the laws are also shortcomings in the codes. So now of course these codes are very likely to become law very soon. And I think what trade unions should look at is pressing for amendments so that the scope of the term worker or employee under these laws can be widened to bring gig workers within their scope and other platform workers within the scope of these laws. And I think he had also asked a question about the adjudicatory mechanism under the laws, or the mechanism for grievance redressal. The mechanism for grievance redressal is provided if it relates to industrial relations. The mechanism comes under the IR code. Then there are different mechanisms under different codes, but under this code, yes, we have a slightly new mechanism of grievance redressal under the industrial relations code. But in the first place, they may not even come within the scope of that code. But of course, they'll come. As far as the right to unionize and collective bargaining is concerned, they will have it, because as Brother Sangam said, gig workers can be broadly considered as workers in the unorganized sector. And that part of the industrial relations code relating to trade unions, chapter 3, that will also apply to unorganized workers. So going by that logic, we can say they'll certainly have the right to unionize. But for other rights, it's all a big question mark. And what are the avenues for grievance redressal they'll have? As on date, it's a big question mark. And then Brother Prakash, yes, the tests which he pointed out about the contract for service and contract of service, the Supreme Court has made that distinction. And then the usual test to determine whether a person is an employee are the tests of supervision and control, which is what I had referred to in the context of the AB5 law of California as well. And he referred to the Contract Labor Regulation and Abolition Act of 1970, which I'm afraid that does not apply to gig workers, because they are not employed through a third-party contractor. Gig workers are not employed through a third-party contractor, and they are not considered as contract labor under that legislation. They are considered as independent contractors, and which is why I was referring to the ABC law, AB5 law, and the ABC test under that law, to show what kind of distinction it makes between those who can be called independent contractors and those who can be called workers. And gig workers are certainly workers. Why I was referring to that AB5 law and the triple test was to emphasize that in our country too, we should say everyone in the world of work should be entitled to the following protections. A national minimum wage, social security, right to organize, right to unionize, working hours of 8 hours a day and 48 hours a week, overtime pay, leave, and so on. And the only persons who can perhaps be excluded from the scope of the law, perhaps, is those who are truly independent contractors, for which the test laid down in the AB5 law will serve very well. That is my opinion. Thank you.
Thank you very much.
Can I ask one question? Last question.
Yes, last question.
Madam, these are the central laws. But as far as state governments are concerned and state employees are concerned, there are so many different laws. Say, Open Establishment Act is different in every state. Minimum wage, every state has different. So there are so many state laws which are contrary to the central laws. So will that be applicable to all the state government only, or central government employees, or all? That's a doubt. Please. Thank you.
Also, Advocate, I think when you respond, the question comes also from a place of understanding from municipality workers and other workers in public sectors. So taking that into account.
So labor is a subject in the under the concurrent list of the Indian Constitution, and that is why state governments and the central government have concurrent power to legislate in respect of labor-related issues. And by virtue of that concurrent power, the state governments also have the power to amend central labor laws. So, for example, the Industrial Disputes Act is a central law. But the government of Tamil Nadu may amend the Industrial Disputes Act, introducing new sections, or in which will have application only in the state of Tamil Nadu. So state governments are also free to amend central labor laws. So now once the codes come into place, similarly the state governments will have concurrent power in respect of that subject. So it remains to be seen how state governments will exercise that power as well. And brother, you are right. Even each state has its own Shops and Establishments Act, which does apply to the IT and ITES sectors. But I mean, you know, whether they offered proper protection, no. In the Shop and Establishments Act, they do give certain rights to workers in shops and establishments. But if you look in terms of remedies and avenues for grievance redressal, it's very bad. Only if a worker, an employee is dismissed from service arbitrarily, then he or she has a remedy under the law. But for example, if their earned leave is not given to them, there is no remedy under the Shops and Establishments Act. So if the Shops and Establishments Act fall woefully short in terms of rights and remedies. And so we also need to look at amending the state shops and establishments laws. You're very correct on that. Those laws also would need to be amended to adequately protect IT, ITES and BPO workers. And similarly, the minimum wages also, they need to be fairly fixed, whether it's the center fixing the wages or states fixing the wages.
Okay, thank you very much.
Thank you very much. And I think that's a very important point that has implications for many sectors, even electricity, healthcare, water, which are at least healthcare and electricity, I think, are clearly under the Shop and Establishments Act. So thank you for this. And I would like to call now on the third speaker that we have for today, which is Professor Shamsunder. Professor, they are these international treaties on economic issues that are wrongly named as trade agreements or even the World Trade Organization, because they are so broad, they cover so many aspects of the economy, and they are increasingly also discussing provisions that impact on digitalization, that impact on the digital economy, the gig economy. So could you give us an idea of if you see that these can have any implications for industrial relation system in India?
Yeah, thanks. Am I audible? Am I audible?
Yes, sure.
Okay. Well, let me give of course, we have to understand that World Trade Organization is a global body that governs the trade and thereby the trade between countries and between regions and between regional trade blocks. Of course, trade blocks are a kind of escape routes to get away from the global treaties. But largely, they would also be governed by the WTO regulations, and the share of services in the total export-import composition has been rising over the last few decades. As we know that we could classify the economy into primary sector, traditional sector, primary sector, secondary sector, and tertiary sector. So many of the services that are being exported and imported, which would fall under the digital trade regulations, would fall under the service sector, and the share of service exports and service imports have gained considerable importance. And there is a need for the WTO to revisit the regulation of the trade in services, the investment in services, and also the property rights in services. So it's a wide ambit, but I've been asked to speak on the industrial relations consequences. So I will look at them, and I would offer a kind of a conceptual perspective in order to understand where we are, where we were, and where we are, and where we are going to be. So, it's very pertinent to understand that technology has been a primary determinant of industrial relations over the course of economic history. So the industrial machinery came, and the factory system came, and then we had the divide between the workspace and the living spaces. And the factory itself can be considered as a kind of a larger technological construct, in the sense that it separated not only the workspaces and the living spaces, and it also created employer-employee relations, and more importantly, it created a physicality of employer-employee relations. And of course, the spatial dimension, that this is a workspace, defined workspace, we all congregate there, and there is a kind of a supervisory mechanisms and subordination, and all those aspects that we need to take into account. And as a result, the wage employment became a construct. And then the entire labor regulations that Rama spoke about were constructed around this spatial and physical and direct interface dimension. So the three things that are central to the labor regulations are the existence of employer-employee relationship. Secondly, there is a physical, it centers on a physical space. Thirdly, there is the direct interface between those who demand work and those who provide work. And then there is a wage employment relationship, and the people were some were management and some were being managed. So there is a wage employment that was created. So around this we had, and the technology was the mediating factor. And of course, even during the industrial civilization, we had jobbers in India who were basically intermediaries between employers and in the labor market, people who demanded labor and who supplied labor. So jobbers were existing, and then they became the intermediary, and then we had from the bipartite relationship, we had progressed to tripartite relationship kind of a arrangement. So we had the principal employer, we had the user enterprise, which is called the user enterprise in the West, and then we had the labor supply contractor, and then we had the contract workers, and of course we had the directly employed. So we had a kind of basically a tripartite regulation system, and then of course we had this global in terms of economic development, we graduated from the agrarian economy to manufacturing economy, and then to service economy. But in India, we did not graduate through the three phases. We graduated from the agrarian economy directly to the service economy, because manufacturing contributes only not more than 16% of the national income. And now I'm coming to the most important aspect as the mediation of technology through the digital mechanisms. I'm not going to talk about only the app-based system. We are talking about the machine learning technology. We are going to talk about artificial intelligence. We are going to talk about other form, robotics and all kinds of systems. Even robotics could be seen to be as digitally driven, because it's, and of course the algorithms. So taken together, all these things, we can consider them as a kind of as a progressively new technology. And what is the impact of this digitalization, which happens not only in the service sector, not only in the manufacturing sector, which can also happen in the agriculture sector. And particularly this, since it is a forum of public service international, it can also happen in the government sector. And the government sector has been principally outside the fulcrum of the labor regulations. They were always regulated by the civil service conduct rules, and thereby all the labor laws would have a clause of non-applicability of these regulations to the government employees, be they municipal body employees or state government employees or panchayati employees or central government employees. So the labor regulations and one of the important issues that has been sidetracked is that the labor regulations concerning the government employees need to be reformed. They are civil service conduct rules or municipal rules or whatever may be. that they need reform, and Mr. Kannan is there, and I hope he definitely. One of the important things about these digital mechanisms is the surveillance. So, I mean, the surveillance mechanism is very important in controlling the employee behavior. In a large, in a large enterprise such as government, public services, what happens is that it is physically impossible, virtually impossible for any management or supervisory mechanisms to track the physical movement of the employees or the digital efficiency of the employees. So when we operate the computers, when we operate the emails, automatically the surveillance mechanism kicks in. Now, why this particular thing has come? I mean, how it is going to impact the industrial relations? It is going to impact the industrial relations in many ways, because the digital the digital transformation is supposed to be transforming from the wage employment into self-employment, which is of course interrogated by unions and others. Basically, this is going to create a kind of a micro-capitalism. What is micro-capitalism? That individuals are empowered with certain skills, and individuals will operate as independent contractors, and individuals will be outside the employer-employee relationship. That is what Sangam has said, that as an employee you will get the minimum wages. If you operate, if you have a car, I mean the taxi, you become a owner, you become an independent contractor. So these are the I mean, or you resign your job as an engineer, you can have a startup and you become an entrepreneur. So self-employed category becomes a dominant category because of the digital transformation, and it creates what is called as micro-capitalism. And you can become intermediaries or you become service providers. So the impact in industrial relations is that you go outside the bounds of traditionally defined labor regulations, which Rama talked about. So as a result, these employees, they do not figure under the industrial relations code, which assumes an employer-employee relationship. They are not under the wage code because they are not a wage employees, obviously. They are not under the occupational safety and regulation code because again it assumes a physical space, and of course they may come under the Motor Transport Workers Act, and thereby they could be regulated under the OSH code that Sangam has to can talk about. What is going to happen is that we are from bipartite, that is two-party relationship, we have moved to tripartite relationship in terms of contract labor system, to multiple parties employ a kind of a system where we have the service providers, where we have the platform, where we have the invisible intermediaries. I mean, the platforms are not going to be regulated. The platforms can be inadequately regulated, and then we have the consumers. And so what is the second important force that is driving is that the whole phenomena of the technology, digital technology, is driven by consumer welfare. I mean, and this is driven by the middle class social welfare theorem, as we call it in economics. I mean, Uber and Ola has assumed a tremendous amount of legitimacy in the society because people are telling that why should they be unionized? Why should they be brought under law? Because they get what for their services, and we have the comfort of ordering the transport from the comfort of our home and hailing, and traveling under very comfortable conditions, and it's a point-to-point system without any kind of hassles. And so it is a consumerism that drives this digital transformation from wage employment into self-employment and independent contractors. Even my fellow colleagues in XLRI are asking me as to why these people should be brought under the ambit of regulations and and why should they be unionized, and why should they be called as employees? They are better off as being called as self-employed contractors. And I have also conducted my own investigations. 1/3 of my interviewees have said that they would like to be called as self-employed or independent contractors, or as even micro capitalists, because they are, some of them have made money to run 5 to 6 fleets of taxis, and there are agencies who recruit, and they provide to the to the app agencies. So there are invisible intermediaries. Now, what are the downsides in terms of industrial relations is that this digital, the digital technologies, they can do two things to the bargain. At the end of the day, what is industrial relations? Industrial relations is all about bargaining power between agencies. Now, there are two kinds of theories, is that because the automation or algorithm driven or various robotics or machine learning technology, they will reduce the demand for certain kinds of labor. So when the demand for labor is reduced, automatically the bargaining power of labor is reduced, and to that extent they would be at a disadvantage. For example, the conventional taxis, now their bargaining power is reduced because there are alternatives called Ola and Uber. So unless and until there is a public service regulation which will keep a level playing ground, the traditional taxis like autos and the taxis, conventional taxis, and the Ola Uber, who can adopt predatory practices, the bargaining power of traditionally placed economic agencies will be reduced. So we require a third party regulation, and it could be national regulation, or it could be an institutional regulation in terms of unionizing, or it can be a global regulation. That is why I asked the question. The second important hypothesis is that, now all are in the form of hypothesis, that these create new skills and thereby provide improved employment opportunities or economic opportunities. I am sensitively using the term economic opportunities and not necessarily employment opportunities, because employment may mean, employment at work, or we make distinction in labor. So when new skills are created, for example, we have in the credit card system, we have the artificial intelligence, which has displaced a lot of supervisory mechanisms. A very simple thing: when I swipe a card, there is an artificial intelligence in HSBC which determines whether Shyam Sundar is actually swiping the card on the basis of history of my transactions. So previously these were done by the physical people. They would have a list, they would have a data, and they would do it. Now it is done by artificial intelligence, and my artificial intelligence, and everything will have to be done in a nanosecond. So people argue that artificial intelligence can promote consumer welfare. And of course, in public service in the public services, for let us say 150 vacancies, more than million applications may come. How does the HR department in the public services, how do they kind of sort out, and how do they decide, how do they shortlist? Now artificial intelligence called human resource data analytics has come, business analytics has come. So they replace the physical functions. So we need to understand that there are three arguments which give legitimacy to these digital transformations that are taking place. Number one, it improves productive efficiency on the part of all economic agencies who are involved. The recruitment process becomes better, and it introduces neutrality, because technology is neutral. But what is important is that all this are algorithm driven. So there could be a fundamental prejudice in the algorithm. That is the fundamentals of fundamental arguments. Secondly, it promotes consumer welfare. That is the second important legitimacy. And thirdly, it creates micro capitalists or it empowers individuals. I mean, there are bad stories, there are good stories in terms of Uberization of employment, but people tend to think that because of these three factors, that we have to move away from the conventional constructs of union-driven, law-driven, and state-driven, income-earning opportunities to the liberalized self-regulating, workspaces, public spaces, and also invisible spaces. So, for example, online labor markets, freelancers are there. So, the freelancers are people who are empowered with certain skills. So, they need to, and they say that we are able to source work not only from India, because digitalism has enabled a person sitting in Jamshedpur to access a service contract from, let us say, Moscow, or let us say somewhere in Brazil. So that is where the global regulations come in. So online market, how best they can be regulated. This is a subject for WTO. So this is a subject for digital trade rules that come in. So and it has its downsides, it has its upsides. But what is important is to understand is what is important for us to understand is that how can we build regulations which will ensure occupational protection, social security, income security, and some kind of a level playing ground, because the skills the accessibility to skills will be contingent on the economic power. For example, if I want to become a Ola Uber driver, if I am rich, I can buy a taxi and drive. Otherwise, it is not possible. So accessibility to skills also, we have a digital divide. So it has inequalities. So it's a very complex subject and it's a nebulous one. And we in industrial relations are trying to find out whether we can expand industrial relations into work relations so that everything could be brought in. Thanks a lot.
Thank you very much. I think we had a very comprehensive kind of perspective that was given this morning. And just to pick up on some of the key points that kind of emerged for me, I think from Sangam Tripathy's presentation, the centrality of data as the tool for which that was used to change the working conditions. Like for instance, we heard about how the wages were pushed down from 70,000 again to 10,000. And in order to be able to do that, what companies were doing is that they were collecting data on how Uber drivers are working in the city, and then using that to create algorithms that, give outputs that are like, okay, I know that generally you do these kind of trips. So when you do them, you will get less money. So it used the data it could collect on the workers to actually trap them into a more and more reduced and decreased wage. We just heard now also from Shamsundar how surveillance is coming into workplaces. And surveillance is again about collecting data and using that data to say, okay, this person is at the work spot and does that much work because they use the keyboard that often. And again, that is used to create calculations, algorithms that can move intensification of work, maybe at some point have impacts on wages. And I also remember when we were preparing another report, we were hearing about the equivalent of the ASHAs, the female community health volunteers in Nepal, having to use an app to enter the data of the different houses where they have gone. And again, that app having the ability to collect data over their work. And again, that creates another space for surveillance. So that element of how data is a central element of digitalization. And as Ramapriya was saying, we need to see how we regulate the digitalization space, We need to see how we increase the regulation that is going to impact on workers in the gig economy, but also other places where digitalization comes in. But it feels that in order to be doing that, at some point, we will have to pick into regulating data use. Are we going to allow, companies to just use that black box? They just collect data, make an algorithm, don't give access to the workers? Or is that some of the entry points that we will have to use? It feels that in order to regulate the digitalization that is taking place across sector, we will have to be able to access the data that is created by companies, access the algorithms, and put certain elements of regulation of those. Now, we just discussed the possibility of global platforms to look at that regulation of data at the global level, keeping workers in mind, keeping the public interest in mind. And unfortunately, I think we all know that that discussion doesn't seem to have started at all. On the opposite, the discussion that actually started is the one that is pushed by the technology companies so that data algorithms cannot be regulated. And that is what is proposed for the moment at the WTO. That, as many of you already know, that is what was proposed as part of the Regional Comprehensive Economic Partnership. It is still there on the table for the countries that are still discussing it. And there has been also analysis saying that the reason why tech is pushing it in that space, it's not because that is the appropriate space to discuss it. It's because this is a undemocratic space where they know they can push certain regulation that would not be acceptable in a democratic space otherwise. So there is also analysis that says that this regulation of data, of algorithms, it's about digitalization, it's about data governance. It has nothing to do with trade, actually. It is not about trading of services. It is not about, that element that is what those forums are supposed to be about. So this is actually not where they should be discussed. It's the malicious intent to push certain frameworks that will not be acceptable otherwise, that has created that situation where that is where we are dealing with that. And I think, as many of you already know, some of the proposals that are there, either at the WTO or at RCEP, is as simple as saying that government should not be able to regulate data or ask companies to show their algorithms. And I think we do understand how that is very problematic from the discussion we had this morning. So I would like to open it again for discussion. We have half an hour left. I invite people to speak. Maybe also for those who are listening in any of the other languages, you can also raise your questions in whatever language you want, either Tamil, Hindi, or Marathi, and we will ensure that it's translated. So please do feel free to intervene. I would like to have more women participants also coming. So no pressure. Who would like to speak first? We do also have.
Are you going to open the forum for questions? Maybe the participants should, if they still have questions based on the three presentations, rather than just the three of us speaking. Anyway, I mean, I could respond to some of the issues raised, but I think it's better if the other people also participate, isn't it? But whatever you decide, yeah.
Yes, I think we can open it a bit more now. I mean, for direct questions, of course, especially if there are questions to Professor Shamsundar, as he hasn't got direct questions yet. I think I can see Kanan's hand is up. Kanan, would you like to speak? Yes, please go ahead.
Okay. First of all, thank you very much to all the three, Professor Shamsundar, Sister Ramapriya, and our great friend, for the presentations. So it's not basically a sort of a question, but then looking at some of the points that have been raised, and especially Professor Shamsundar was especially mentioning about the sort of public services and the government employees. So I just wanted to sort of raise some things here. See, basically the labor codes, now it's the 4 labor codes that are there. So one of the things that is clearly mentioned is that these codes have no direct, I would say, yeah, there are a lot of implications, but then the government employees are not directly having impact, because these are all covered by the conduct rules, civil service conduct rules, the state civil service conduct rules, and the central civil service conduct rules, right? So they are there. But then there has always been talk like having the reforms, but then these codes are have not even touched upon that. But then there are a lot of these reforms are ongoing, but what it happens is that the like the other labor code, other codes for the conduct rules, they are there for many years. Like most of them are governed by the British, and still we are following these sort of following the conduct rules. So one of the thing as of now what we are seeing is that the codes are getting more are used in a very sort of negative sort of an aspects, in the sense like people who join the sort of government, so they have, and also the people outside, though, they think that like once they join, so they are there forever, like till their retirement or 60 years or whatever it is. But then now if you see, they are using all the existing the rules. Like for example, like now they are saying that at the age of 50, or if you have crossed 25 years of age, okay, they are reviewing now. And as of now, there are many people who are just sort of, they have to be, it is not resignation or something like that, that is retirement at the age of something that is happening. This is happening very much. And second thing is, earlier when we had the numbers, we just look at the central numbers and the state numbers. Like in the central government now, we have more than 11 to 13% vacancies are there. In some of the states, it's more than 30, like 20%. I know in Karnataka, they have more than 20% of vacancies and all that. What they are now trying to do is like using these people as not as companies, and it is basically the contract and casual workers who are coming in. The problem is they will not be covered under this sort of a rule. The contract and casual people, they will not be ruled under the contract rules. So there is a sort of a big gap that is there. Second, in terms of this digitalization is coming there everywhere. Like you said, the gig employees and all these things. But then including the public services, now the government employees, a lot of this digital sort of work that is going on. If we talk about the 1990s, the major threat was the computerization. So computerization was seen as a big threat, coming number. But then now digitalization, yes, what now they are seeing is that they are now going to bring the numbers down. They have already started doing this and using those the people, because since the job has to go on and on, right? So they are now using digital ways of digital to bring down the sort of numbers. So I think there is also need to sort of discuss on how the digitalization is bringing down the not just only the public employees, but also the sort of workers who are there. The numbers are coming down, the working conditions are coming down. So these are some of the areas I think we need to discuss within the digitalization. Thank you.
Susana, I just want to ask Kannan something.
Yes.
Yes, please go ahead.
So Kannan, there are three issues that I would like to know about in this particular conversation that we are having. One is that, do we have a database on the people affected by introduction of new technology, such as penetration of artificial intelligence or any kind of technological use that have come into public services in India? So that is my question number one, because a lot of private companies have resorted to this data analytics, and I'm told it is going to be introduced in central government services. To what extent this has data analytics has penetrated government services? It will be good for the union as well. And second one is that, what is the extent of surveillance in and data gatheration of government employees? And third one is that I'm told that post-COVID, with the introduction of technology, work from home, which will have huge consequences, which I did not mention in that, work-life balance. That is the physicality of the spheres, work sphere and living sphere being intertwined, which will have consequences even for occupational safety and health. So work from home, Susana, this is one point that I would like all of us to debate, is that so far, I do not know whether ILO has introduced any regulations. There is a need for regulations on WFH, work from home. For example, we professors are now working from home, government employees are working from home, advocates are working from home. So this is mediated by digital devices. And it also means sharing of my private space. So can the trade union ask for regulations relating to work from home? That is my third question to Kannan, Mr. Kannan in particular, and all others in general. Thank you very much. And also, there is a depth of data on the public services. In Economic Survey has stopped publishing data on the public services and wage outcomes. Thank you.
Thank you.
Particularly, I'm concerned about regulation of WFH, which is going to penetrate government services. Is quite a government service. Thank you.
Thank you. Kannan, please go ahead.
Yeah, thank you. Yeah, thank you very much. Maybe I may not sort of respond to all the things, but then some of the things that I know well, so maybe I will sort of respond. Yes, there has always been, the gathering, information gathering through digital, right from not now, right from there, especially in terms of public employees, it has always been there. That's So one example that not only the government employees, but everyone knows about the Aragya Setu, right? So when first thing that was informed is that all the government employees should be having like the Aragya Setu when they first wanted to go for the work and all that. There has always been this. In terms of the regulations from work from home, right? So this is again a major concern, because this basically the working from home, the issue or the sort of regulations is not basically in terms of the persons, it is basically in terms of the services that is there. So for example, like all those in the health service, like for example, the government employees. So if you take the government employees in the states or in the central, like, so everyone after this, the pandemic has come in, so they are asked to work, not just from home, it has to go to work. So that is a sort of a compulsory thing that has been happening. So we have also identified where the government employees or the public workers, those even in the contract, like who they have, like for example, they are more than 50 years of age, So where they have some sort of health issue, they are asked to work from those. So in terms of the government employees, I think some of them would even like to go work from home, but they are not given that sort of a choice. They are asked to go to the offices. In most of the yesterday there was I saw in the newspaper that all the unions here, I saw in the news here in the Chennai. So they are asked, they asked the government that they either be given a choice to work from home, or they has to be, like now they are to work 6 days a week. Basically it was 5 days a week. Now they have increased to 6 days a week after the pandemic and all that. So there are actually there are a lot of issues that are there in terms of the work and looking at the work-based balance. So most of them, including all Saturdays and Sundays, they are working every day, 7 days a week. They are there. So when the question is raised, in the question raised, they are saying that as sort of government employees, it is it is your sort of a responsibility to safeguard lives. It's between the lives issue and all that. So there is always a issue whenever the public employees are mentioned on this. I think you were also asking a question like, do you have a sort of a data on, basically we don't have. So basically it would be really good, like, yeah. So it would be good, like, if we will also try to collect sort of the data on the who are in the sort of a digital platform. What is the sort of impact of the digital platform on public services and all that. Maybe we will look at options of how to come out with this sort of data in future. Thank you for bringing this to the notice. Thank you.
Thank you very much, Canon. And I have also shared the link to a report that PSI published recently on digitalization in public services, which is a global study. It's as Canon said, we don't have data specific to India or like a comprehensive, but this is the beginning of what the PSI has been working on. I have a few people in queue, Narasimhan and Ranja, and then I saw Sangam also put his hand up. So maybe we'll go in that order, and I'll start with Narasimhan. Narasimhan?
Yes. Actually, the technicalities, legal issues have been already raised. But I would like to say, in spite of all this, if the government wants, they can always ensure what they want as far as government employees are concerned. Till now, we have seen essential services being invoked against the LRG sector or the local employees of the state. But now, during this pandemic, the financial sector employees like the LIC, the Life Insurance Corporation employees, and the banking employees, they are brought under essential services. We are at a loss to understand how the insurance and banking services come under essential services. And again, there is no protection for the employees covered under this. If you take Mumbai and Hyderabad or Chennai, during the peak, they were asked to come to office without any protective gear. The only benefit which was given was having a sanitizer at the entrance. We don't even know how to take care. The policyholders come, they come with the cash, which is not sanitized. They come with the papers, which is not sanitized. The employees were getting infected. So if they get infected, because of the duties which they performed in office, they have to apply for leave and take treatment. And if a family member is infected, quarantine leave, they are eligible, but they say technically COVID is not included in the rules, quarantine rules, which has to be amended by the parliament. So these technical issues come to the fore, how the employees are dealt with. And regarding work from home, if you take work from home, lot of circulars, information, material has been provided by the government with regard to the work from home for public employees. For private employees who are in the IT sector, because I am also an IT employee in public sector, it is very easy for them. Connectivity of the laptop is there, you can sit in your house, start working. Basically, this work from home concept is introduced not in the interest of the employee, but in the interest of maximization of profits. I don't want to pay rent, you work from home. I don't want to pay for the conveyance, you work from home. I don't want to pay for the refreshments, work from home. I want to extract more work outside the office hours, that is outside 8 hours, work from home. And I will put a condition, you cannot leave the headquarters, you should always be available online whenever I want to assign any work to you or take some response from you. So it is more getting murkier for the employees, because in the garb of allowing them flexibility, actually they are making them accountable for things which they are not accountable generally. So the house is converted into an office without making any changes in the rules, without making an additional payment, without having the employee or his interest as the focal point. But everybody is happy. I'm allowed to work from home. Actually, they are having more time for work-life balance if they are in the office than working from home. So these issues have to be looked into, where not only the legal provisions are violated, but also new provisions are created in the interest of the corporates, in the interest of the managements, against the interest of the workmen, which have to be looked at in the new perspective, and the solutions have to be sought, because if you go to a labor court, it may take to conclude the process of conciliation, arbitration, and ultimately litigation many years. By the time the purpose of the taking up the issue would be defeated. I would like to quote a small case where the issue of regularization of temporary workmen in LIC was taken up before the conciliation, arbitration, then it has gone for litigation, it has gone to Supreme Court, we have got a favorable order, management has gone on appeal, then a curative petition. 30 years have passed, still it is not implemented. Still it is going on. So some time frame also has to be set up, so that if I go to a court and win a case after 30 years, how many people can afford that in this fast-paced thing? So we have to ensure that justice, and with a time frame within the legal framework, because the new courts only ensure that the old infirmities continue and new infirmities are added. This has to be looked into the labor perspective also, and solutions are to be worked out through taking up the issues at various forums. Thank you.
Thank you very much, Narasimhan. Ranja, who will next in queue?
Yeah, thanks, Susana. I have two quick, one is a question and one is a comment. Can you hear me? Can you hear me?
Yes, we can hear you.
Yeah, okay. So the question is with regard to self-employed workers. I wanted to ask both Sangam and Professor Shamsundar, because you both raised it, especially in some of these, in this platform economy. I mean, this complex labor relations, because some people are actually in the self-employed category. So therefore, I think and Professor Shamsundar, you mentioned that they actually want to be in the self-employed category. They wouldn't want to be called workers, right? So what is it that advantage? Because what the problem we are perceiving is that they are self-employed, but at the same time they're controlled by the companies and the algorithms. It's not like they can, they don't have that flexibility that other self-employed workers who may be having low incomes, but they have a flexibility and an independence. So what is it, that advantage that they perceive? That's my question. Second thing is, I wanted to quickly support Susana's point on trade. I don't think we want the WTO or any of the trade agreements to make rules on this, because we know that these trade agreements, these trade spaces are dictated by companies, big multinationals bring in their corporate interests. These are very hard commercial negotiations. We have not seen the interest of labor being addressed in any of these platforms. And in fact, as Susana mentioned, some of the proposals that they are bringing in, one is they wouldn't have any physical presence. Which means that, if you want to catch them as the employer and get them to implement certain labor codes or conditions, or, even comply with the domestic labor laws, you cannot catch them, because they need not have physical investment and physical presence in the country where they are operating. So I think so we will not be able to catch companies like Uber and even Amazon, because it will make very difficult to implement labor laws. And I think if we want to bet on a global platform which would actually protect platform workers' rights or workers' rights in the digital economy, it would be, my bet would be the ILO, not any of the trade platforms. In the trade, we want actually minimum rules, minimum intervention, because as Susana said, all the rules that are being proposed are basically gives a lot of flexibility, freedom, and basically it allows deregulation. It will not allow any regulation to come in for these companies. So that would be my comment. Thanks a lot.
Thanks a lot, Ranja. And we have 5 minutes left. So what I would like to do is give a last word for the three speakers of the session. And Sangam, I think you have several questions and you also wanted to intervene. There was one question that was asked initially by Professor Shamsunder about the question of the global platforms that would be best suited for discussing workers' issues in digitalization. So maybe if you want to elaborate on that, that's also what we are discussing, any other points that you want to make. And then after that, I'll also, in the same order, call on Advocate Ramapriya and Professor Shamsunder before we close.
Thank you. Yeah, so quickly coming first to the Shamsundar's question which he had raised. I think there's no magic wand, that you call upon the ITF to have a global regulation or a global negotiation with Ola, Uber, these companies. There's no magic wand. The moot question here, or the moot way forward, is to organize the workers. And that is, we are at a very early stage today. So in the USA, in Europe, at many places in Asia, a few places in Africa, unions have already started organizing the app-based transport workers. So I think when we come to a stage where we have enough kind of bargaining powers, or when our profile is raised a bit, that's the time. There are a lot of efforts going on. We are also networked internationally. We have an international alliance of app-based transport workers that is trying to do a lot of work legally, policy-wise, even organizationally. So a lot is happening, but I don't think any organization, I think what Ranja said was right. I mean, right now we are contemplating as ITF and as other govs also of how we can bring about discussion in the ILO to have a convention to regulate the app and gig and the platform workers. So I think an ILO convention is the need of the hour, and that is what we are trying to also push. So that's as far as his Shamsundar's question is concerned. I wanted to make 2 points, because many of the people here are trade union people, and maybe many of the people here are from public sector employment. We have a lot of public sector employment in transport also. But I want to raise a more important and a more fundamental question here. The way things are going in India, we foresee that in the next 10 years or so, the majority labor force of this country, I would even go to an extent to say 60 to 65% of the labor force in this country will be delivery boys, and app-based workers. the way the trend is going. Look at the way Amazon is progressing. Look at the Flipkarts. Look at the urban companies. You know, what was Urban Clap earlier. Look at Ola. Look at Uber. So this country will, in the next 10 or 12 years, become a country of delivery boys. Yeah, and people who work for app-based workers. So that is something we as a trade union movement need to sit and reflect upon. You know, what is the future labor force of this country? Number one. So as a trade union movement, we have to start thinking, do we want to organize them? Do we want regulation? You know, because a lot of people raised about issues about people being happy as contractors, small contractors or independent contractors. I think that is a very, very small fragment of people who have 2 taxis or who are fleet owners or 5 cabs. Majority of the people are single cab owners or cab drivers, or their cars have been leased from Ola and Uber, so on and so forth. So regulation is important, and we need regulation of this entire platform workers sector. What are we talking about? We are talking about basic rights. We are talking about basic rights to employment. We are talking about basic rights to working conditions. We are talking about basic rights to organize. You know, collective bargaining, I think, is still a very distant scenario. We don't have any experience of any collective bargaining success so far, either with Ola or Uber. And we are talking about social security. So 5 basic rights. That is where our fight is today. And not just for Ola and Uber, but I think for the emerging, you know, army of platform and gig workers. So that's the one point I want to make. The second point I want to make is that is something we have to be very careful, whether it is PSI, whether it is ITF. We talk about public transport workers, public sector workers. Now, we have examples of companies like Uber, for example, have gone to cities or municipalities and, you know, the state governments globally and said, you know, that we could provide a good public transport system. So they are already forcing a future where they want to replace the existing public transport system. Okay, we can see glimpses of it already in our own country. They have made agreements with DMRC, the Delhi Metro Railway Corporation here in Delhi, to provide the last mile connectivity from the railway station to the homes. They're doing similar things in Bangalore. They're doing similar things in Hyderabad. Now, I'm not saying, now maybe Shyam Sundar will say, well, for the consumer, it's good. So what's bad about it? I'm not concerned. What I'm concerned is that last mile delivery worker has to have rights. And when he or she has rights, I'm not concerned whether it's Ola who's taking the last mile. Ideally, for PSI or for the ITF, we've always been saying, and we will keep saying this in the future, public transport should be in public ownership. Access, affordability, these are questions, and more so important for a country like ours, you know. So I will not talk more. I just wanted to make these 2 or 3 points, and I think I have covered many issues which were raised by colleagues. Thank you.
I'll just ask Ramapriya to go first, and you'll be able to speak last.
One thing which I wanted to point out is across sectors, be it the public sector, private sector, or the gig economy, or the ITS sector, what we are witnessing now is the employers want to avoid responsibility. And the persons employed by them, they want to say they are not my employees. They are either self-employed or independent contractors or contract labor or something. But everywhere employers want to avoid responsibility. They don't want to say these people are my workers. They want to deny the employer-employee relationship and disguise the employment relationship. So we should look at how to make the employers more accountable, and regulation through law is one of the ways of making the employers more accountable. And so we should push for further reforms in the law, reforms of a pro-worker nature that will make employers more accountable and responsible, and reforms which will really afford universal coverage for all the workers. All persons in the world of work need to be brought under the umbrella of protective labor laws, and we need to push for that. Thank you.
Thank you very much for these last words, Ramapriya.
Hello, can I come in, Susana?
Yes, please.
I can't hear anyone. I can't hear. Hello?
Yes, please go ahead.
Yeah, thanks. Sangam, you got me wrong when I said that it's consumerism. I just said that the trade union movement must tackle the three legitimacies that are cited to encourage these kind of digital arrangements and creating a kind of micro capitalism which is going to haunt us in a conceptual sense. Consumerism, economic efficiency, empowerment, micro capitalism, access to skills. These are the typical arguments that are floated by neoliberal economic philosophers, and these are powerful ideas that get the government as well as the middle class, which shape the public opinion. It was not my opinion. As an economist, I floated these arguments to be tackled by the trade union movement. Please do not misunderstand me. And you have seen, all of you have read my articles and quotes, so you know where I come from. So the basic problem is, Susana, I would summarize this three important agenda, and Kannan sir, you are there, that Public Service International or global union federations must take up at the global level to have a kind of a global framework agreement, which all of you know about it. Can we have something on the digital economy, a global framework agreement? Because all these are driven by multinationals, Indian or Western. That is my point number one when I talked about global regulation. Secondly, it is time to push for an ILO instrument. It may not be a convention, but to push for a convention, maybe achieve a recommendation like the employment relationship recommendation that we had in the 2000s. Thirdly, it is very important that public services have been outside the entire reform debate. The civil service contract rules, as Mr. Kannan has said, are colonial and are draconian. And yeah, someone mentioned ESMA. It is time that public services, reform of regulations of public services, and the digitalization and the surveillance and the work from home, which has become a new reality. There are two new realities that have come. One is the work from home, another is self-employed. Whether a person prefers to be self-employed or not, as Sangam said, self-employed are going to crowd the labor market. So we, as Rama said, we need regulations, we need trade unions. I'm all for that, but we need to take it in an intelligent manner. That is my entire request. So the public services, the civil service contract rules must also enter the reform debate. That with these submissions, I conclude my. I have talked more at the theoretical and conceptual level, but because it was important, because all of you are practical people, it is my job as someone to provide the conceptual level and ask for your understanding to tackle them in the realm of ideas and also at the realm of action. Thank you.
Thank you very much. No, very well taken. I think your recommendations are also very well taken. I think it was a very good discussion, both the initial section with the speakers and now a very interesting discussion that we just had. So I want to really thank everyone who participated. Just to remind everyone, so this is the first in a series of 3 webinars. And while we look more at the discussion around gig workers, platform workers, to understand the sector that is at the cutting edge, the advance of digitalization in the more around the question of public services. And I think you made a very strong point, Sangam, that yes, from PSI, we do believe that public services should be provided by the public sector so that they are able to ensure affordability, universal and equitable services. And the question of the denial of responsibility that was raised by Ramapriya, I think is very important. And it is a reality in the public sector too. Public employers are also trying to get out of their responsibility. So is, I think, through a lot of leads that we will be able to take up again in the next session to look at how that comes together in public services. So I want to thank everyone, thank our interpreters also. I think they have done an excellent job, and everyone who was involved